John Roberts there at the red desk on the right side of your screen, waiting for Senator Specter to come back in and chair this committee back into action. Fred Thompson on your screen, who the Bush administration designated as the person to shepherd or guide Judge Roberts around Capitol Hill and through these hearings. Former senator and former actor. Fred Thompson, of course, currently appearing on NBC's Law and Order series. 3 senators are coming up in the queue for 30 minutes of round 1 questioning, as they call it. Russ Feingold of Wisconsin will be first. He's a Democrat from Wisconsin. Then Lindsey Graham, Republican of South Carolina, and Charles Schumer, New York Democrat.
The hearing will resume. Just a little late in coming back because we're on the floor trying to figure out what the Senate schedule is going to be, when we would vote next. And while that's uncertain, I believe it is reasonable to conclude that we will not vote until 7:30. That gives us latitude to move ahead with 5 more rounds, where we will finish at about 7:30, a little later because we're not starting quite at 7:45. So we will proceed with Senator Feingold now, and then Senator Graham from 5:30 to 6, Senator Schumer from 6 to 6:30, Senator Cornyn from 6:30 to 7, and Senator Durbin from 7 to 7:30. That's back by 15 minutes because we're 15 minutes slow coming out of the gate.
You also look at sheer undisguised glee on the face of Judge Roberts at the idea of going another 3 hours of this.
Well,
2 hours.
I consulted with Senator Leahy, Judge Roberts, and the empirical evidence is overwhelming without consultation that you're fit to go indefinitely.
I'm ready to go.
Is that judgment Satisfactory to you,
Absolutely.
Judge Roberts? Senator Feingold?
Thank you, Mr. Chairman. Judge Roberts, the eyes of America are on you this week thanks to what our generation called the miracle of live television. Television plays an enormous role in providing information and bringing the country together in times of national pride like the liftoffs and the landings of spacecrafts and presidential inaugurations, political conflict like the 2000 election and the 1999 impeachment trial of President Clinton, the great tragedy of September 11th, and the devastation wrought by Hurricane Katrina. Americans can watch virtually every significant event of national importance on television, except for oral arguments and announcement of decisions at the Supreme Court. If you are confirmed, you will essentially disappear from public view. This hearing will in some ways be the last time that the nation will see you at work. The possibility of televising trials raises some complicated issues because we have to consider the safety and rights of criminal defendants and witnesses and jurors, but such concerns are not so present in the case of appellate proceedings. There is no doubt that there is enormous public interest in Supreme Court oral arguments, but not very many seats in the courthouse. I think it would benefit the country and the court if all Americans had the chance to see the court conduct its work, so I'd like to know if you, as Chief Justice, will support televising the court's public proceedings.
Senator, it's not something that I have a settled view on, and I do think it's something that I would benefit from the views of my colleagues, and I know that some of them have particular views and some may not, and I noticed the last time there was a formal response by the court to a request to televise a particular argument, the Chief Justice referred the matter to the whole court and then reported back on it. I'm also aware that there are, I'm not sure if the right word is experimental or trial efforts going on in some of the courts of appeals, the federal courts of appeals, to televise arguments there. And I know I've watched them. So I appreciate that opportunity. And I don't know yet if there's been an evaluation of how that experiment's proceeded, whether the judges thought it went fine, the lawyers, or whatever. I just don't know. At the Supreme Court level, I do know they've experimented recently in a few cases with releasing the audio tapes immediately after the conclusion of the argument. Again, I've listened to those on occasion. Not every case, but selected cases of particular interest. I know that on our court, my court, I'm sorry, on the Court of Appeals for the D.C. Circuit, we broadcast, at least within the courthouse, simultaneously the oral arguments. So I know that the technology is there to do that, and I certainly understand the interest, and I understand how, I know it was very well received to have the audio tapes immediately available in some of those cases.
I hope you'll seriously consider this. So what's changed from our good conversation we had about this before is that now you will be the principal decision maker on this as the Chief Justice, and I hope you'll give it serious consideration. Judge Roberts, on September 11, 2001, obviously an event occurred that had a profound effect on all of us in this country. We all have our own memories of that day. During those first few hours after the attacks, I kept remembering a sentence from a case we both probably studied in law school. These words were, "While the Constitution protects against invasions of individual rights, it is not a suicide pact." I took these words as a challenge to my concerns about civil liberties at that horrible time in our history. We have to be careful not to take civil liberties so literally that we allow ourselves to be destroyed. But then when I actually tracked down the case itself, not remembering what case it was from, it was Kennedy versus Mendoza-Martinez, and I found that Justice Arthur Goldberg made this statement, but then went on to rule in favor of the civil liberties position in this case. He actually affirmed the importance of civil liberties in wartime. So I'd like to start this part of my questions by asking you what kind of impact that day had on you and your belief system, and whether it changed your view of the importance of individual rights and civil liberties and how they can be protected.
Well, I remember the day vividly, Senator. I think I was one of the last people in the country to find out about it. I had gone into a hearing. It was actually in an original action in the Supreme Court. The special master was at GW Law School, and we had a hearing. I think it was starting a little before 9 that day. And we went in there. I remember just as I was leaving getting a report that a plane had struck the World Trade Center, but it was at the time, I thought it was like, you know, one of those tour planes. I had no idea what they were reporting. I went into the proceeding, and we conducted the hearing. It lasted several hours. Nobody notified us, and we didn't know about it. And I remember leaving and trying to walk back to my office. I was at the law firm then, and the street was blocked off, and I figured, well, there's something going on at the White House. I remember walking down further, and it was still blocked off and still blocked off. And I finally went up to one of these guards, and I said, well, you know, what's going on? And he looked at me like, well, where have you been? And only then did I begin to appreciate it. I went back to my office because there was no way to get out of town by then.
But at what point did you start thinking about the implications of this in terms of of civil liberties and the challenges this
Well,
places?
it was when I went back to the office and saw the smoke rising from the Pentagon. And as you can imagine, that was a chilling sight. And the basic issue of how you address the question of civil liberties in wartime, in times of crisis, is a critically important one. The Bill of Rights doesn't change during times of war. The Bill of Rights doesn't change in times of crisis. There may be situations where the demands are different and they have to be analyzed appropriately, so that things that might have been acceptable in times of war are not acceptable in times of peace. I think everyone appreciates that. But the Bill of Rights is not suspended, and the obligation of the courts to uphold the rule of law is not suspended.
Did you recognize at that moment that this might become a time when it would be harder to protect civil liberties?
I think I don't recall recognizing that in particular, but that is, of course, always the challenge in times of war and in times of stress, whatever the cause. I think it is the obligation of the courts to remember, just as really the motto of the D.C. Circuit from the earliest case, when the treason trial of Aaron Burr, to calmly poise the scales of justice. And the emphasis is on calmly. It requires a certain dispassion, a certain separation from the passions of the moment.
That's absolutely right, and that's why I want to follow on what Senator Leahy asked about earlier. A different time, a different challenge. As a nation, we can now look back at wartime Supreme Court decisions like Korematsu versus United States with something like bewilderment. We talked about it earlier. To me, it seems inconceivable that the United States government would have decided to put huge numbers of citizens in detention centers based on their race, and that the Supreme Court would have deferred to the President's decision to do so. Do you believe that Korematsu was wrongly decided?
It's one of those cases that I don't think it's technically been overruled yet, but I think it's widely recognized as not having precedential value. I do think the result in that case, Korematsu was actually considered the exclusion, and not the actual detention, but the exclusion of individuals based on their ethnic, racial background from vast areas. It's hard for me to comprehend the argument that that would be acceptable these days.
It's often included if you list decisions that are sort of considered some of the worst decisions in the history of the Supreme Court, with Plessy versus Ferguson and Dred Scott and others. Is that a fair characterization of your view of Korematsu?
Yes.
Are there any elements of the government's response to September 11th that you think 50 or 60 years from now we as a nation will look back on with regret?
Well, I'm sure there are some, Senator, and when you have the benefit of 50 or 60 years to look back, as opposed to the particular demands of the moment and the perceived demands, I'm sure it's a different perspective. I'd hesitate to mention any in particular because so many of these issues are coming before not only the Supreme Court, but the court on which I now sit. And I will have to confront those cases, I think, regardless of what happens here. So I'd hesitate to identify particular areas of concern.
I understand your caution. I don't think we need to wait 50 or 60 years for some. For example, do you have any concerns about the practice of extraordinary rendition, of our government secretly sending people to countries that we know use torture?
Well, again, Senator, that is something that could come before the court in one form or another, and I think I have to refrain from commenting on it.
How about the federal government using immigration laws to round up and detain people for months, often without regard for whether they had any connection to September 11th investigation, which actually in this case the Justice Department Inspector General later heavily criticized. Now, does that trouble you?
Well, yes, certainly. At a basic level of appreciating that this is a reaction in a particular way that raises serious questions. I'm very hesitant, though, again, to express a view on legality because those issues could come before the court. They are coming before the court, and they're coming not only before the Supreme Court, but the court on which I now sit.
Let's go to one that's already come before the court. The Hamdi case is one of the most significant recent decisions restraining executive branch power. In that case, 8 members of the court found that the government had gone too far in claiming the right to detain and hold a U.S. citizen incommunicado within the United States without access to a lawyer and without charging with a crime. The case actually resulted in 4 different opinions with 4 different views on the President's power to detain a U.S. citizen indefinitely and without trial, ranging from Justices Souter and Ginsburg, who found that the President does not have any authority to detain citizens as enemy combatants because such detentions had not been congressionally authorized, to Justice Thomas, who would defer entirely to the executive branch. Which of the 4 opinions, in a case that's already been decided in Hamdi, would you say best approximates your views on the executive powers to designate enemy combatants? The plurality opinion, the Souter-Ginsburg opinion, the Scalia-Stevens dissent, or the Thomas dissent?
Well, Senator, that does get into the area asking me to comment on which opinions I think are correct, that I don't feel it's appropriate for me to go. I do know that the approach in this area is the approach set forth by Justice Jackson in his concurring opinion in the Youngstown case. That has set the framework for consideration of questions of executive power in times of war and with respect to foreign affairs since it was decided. And as you know, the issue in those cases and in many of the cases in the Supreme Court is whether Congress has endorsed the executive action, in which case the President has his powers and the powers of Congress, whether Congress has prohibited the executive action, in which case all he has is whatever residual authority he has, less the power of Congress, or what often happens in that vast middle area where it's impossible to tell or there's argument about whether Congress has approved the action or not. The Dames and Moore case that was decided in 1981 is an example of that, when to resolve the Iranian hostage crisis, the President abrogated claims and relegated those with claims to the Iranian Claims Tribunal. The issue there, the Court looked back at a variety of congressional enactments going way back to the Civil War to try to determine if this type of exercise of authority is something Congress endorsed or opposed.
But with regard to these opinions, and I understand your hesitance to comment on a particular opinion or the nature of the reasoning, but which of the approaches, in terms of the actual finding of the opinion, do you find closest to your view?
Well, again, I don't remember which of those opinions follows the Youngstown analysis the most closely. My understanding of the appropriate approach in this area is that it is the Youngstown analysis, the one set forth in Justice Jackson's concurring opinion. And I think that is the most appropriate way to flesh out the issues. You do need to understand, because this is an area in which the judges need to understand, there's often conflict between the branches, and you do need to at least set the table correctly to understand, is the President acting with congressional support, against it, or do we have to try to determine which of those areas it is? And I think you do need to lay that analysis out before deciding the case.
Last month when I was home in Wisconsin, a constituent came up and said to me that he believed the D.C. Circuit decision in the Hamdan case, a different case, which you joined in to uphold the government's ability to try a Guantanamo Bay detainee by military commission, should disqualify you from being on the Supreme Court. Now this is apart from the issue that Senator Schumer and I wrote you about, which I'll turn to later. I want to know, with regard to the substance of the decision, why do you think someone would think that your decision in that case, why would somebody come up to me and say that your decision in that case should disqualify you from consideration as a Supreme Court justice?
Well, Senator, you've touched upon an area in which I cannot comment. That case is still pending. It's pending before the Supreme Court. Under the judicial canons of ethics, Canon 3A6, I'm not supposed to comment publicly in any way about a case that's still pending.
I'm not asking you to comment on the case. I'm asking you why you think somebody who I represent would care enough about this issue that they would say this should be a disqualifier. In other words, characterize what is the issue in the case that would make somebody that concerned that they would make such a statement?
Well, the issue involves the same sort of issues that you began the discussion with, the question of civil liberties in wartime. And certainly I understand people having strong views on that particular question, but whether the decision on the merits was correctly resolved or not, or anything about it, I'm just absolutely prohibited from talking about it by those judicial canons. There's even an advisory opinion that explains that that canon applies to a Senate confirmation hearing. So my ethical obligation not to comment publicly on a case that's still pending prevents me from saying anything more.
Of course, I respect your judgment on these matters, but I believe that it's important that a nominee indicate a sense of why people in this country might have some anxiety at this point about the difficult events that have occurred since September 11th and how it creates a climate sometimes of fear, in particular fear of government power, that I think it's important not only for members of Congress but even members of the Supreme Court help minimize. And I'm just trying to get a sense if you feel that concern in the nation.
I certainly don't minimize the significance of a decision by the Court of Appeals or by the Supreme Court about the scope of executive authority in this area, about its impact on individual liberties, about the issues of separation of powers and whether the relation between the Congress and the executive, whether the executive is acting with congressional endorsement, support, or in the face of congressional opposition. Those, of course, are very sensitive issues and always have been throughout our history. I certainly appreciate that. Those are significant matters. It's just that I'm prohibited from talking about the substance of the case.
Let me talk to an aspect of the case that I think you can speak to. Many people were surprised to learn in your questionnaire submitted to the committee that you were interviewed by the Attorney General in connection with a possible vacancy on the Supreme Court on April 1st of this year, just 6 years before you sat in the panel that heard oral arguments in the Hamdan case. And that while the case was still pending, before a decision was issued, you had additional interviews in May with the Vice President, the White House counsel, Mr. Karl Rove, and other top officials. I'm going to give you an opportunity to explain why you think it was not necessary for you to recuse yourself from the case. But first, I'd like to know, did the possibility of recusal, because you were under serious consideration for Supreme Court, occur to you, or was it raised with you at any point prior to the oral argument in the case?
Well, Senator, that again is a question I can't answer for you. I can't address that. There's a motion pending in the court seeking to file a petition to recuse, and that motion is pending. It's a matter I can't talk about outside of the judicial process. In addition, because the Hamdan case itself is still pending, I don't think it's appropriate for me to address that.
Judge, I'm a little disappointed with that answer. As you know, Senator Schumer and I sent you a letter asking questions about this issue, and then we received a letter on September 1 from the Assistant Attorney General for Legislative Affairs at the Department of Justice on your behalf. It says, quote, "Your August 24th letter requests that Judge Roberts answer certain questions regarding the D.C. Circuit's recent decision, Hamdan versus Rumsfeld. As you know, Chairman Specter has scheduled hearings on Judge Roberts' nomination to begin immediately after Labor Day. At that time, Judge Roberts will be available to respond to questions from all senators on the committee," unquote. Now, I took that to mean a little more than telling me you couldn't talk about it. Are you now refusing to answer a question even about when this issue
Senator,
came to your attention?
Senator, we're talking about the canons of judicial ethics. They're quite clear on the subject. They say I may not talk about a matter that's pending before the court.
Even when it first came to your attention?
That matter is pending before the court. My hands are tied. It's not something I can discuss under the canons of ethics.
Guess I'll have to move on. Let's go to voting rights. I want to follow up to Senator Kennedy's questions about the Voting Rights Act, and in particular about your opposition to amendments to the Act in 1982 when you were an advisor to the Attorney General in the Reagan administration's Justice Department. In 1982, Congress voted overwhelmingly to amend Section 2 to reinstate the test for vote dilution that many lower courts had used prior to the City of Mobile case, one that looked, as we talked about earlier, at the effects of an electoral scheme on the ability of minorities to elect candidates of their choice rather than on the intent behind the scheme. While you were in the Reagan Justice Department, you seem to have done almost everything in your power to thwart that congressional effort. Your view was that the intent test should stand, This was the policy position of the Justice Department, which as you've indicated, and you wholeheartedly supported at the time. Your memos make that very clear. In one memo, you lamented that the House bill then under consideration would make it much easier to attack, quote, such widely accepted practices as at-large voting, unquote. Now, those practices, of course, were among the most commonly used systems to prevent the election of any minorities to local government bodies. We know that the effects test put into place in the 1982 amendments to the Voting Rights Act has been very successful in improving minority representation in Congress and at all levels of government. Do you believe today that those gains have been good for the country?
I think the gains under the Voting Rights Act have been very beneficial in promoting the right to vote, which is preservative of all other rights. The issue about how to extend the Voting Rights Act, again, my position was a member of the staff in the Justice Department. The administration position of extending the Voting Rights Act for the longest period in history, as is, without change, was in no sense reflective of any disagreement with the proposition that the Voting Rights Act was extremely valuable in securing not just the right to vote, but all other rights.
But what I'm trying to get at here, Judge, obviously, is this distinction between effects and intent. I mean, let's follow up on the fact that you said that these gains have been good for the country. Do you believe that these gains we've seen in minority representation would have occurred if your view supporting the intent approach had prevailed in 1982?
Well, I think some of them would have. I don't know if all of them would have. It's obviously impossible to tell, to go back and determine whether a particular application of a different approach would have had the same results or different results. I think that's very hard to
Do you still believe that the intent test was the more appropriate standard by which to evaluate vote dilution claims?
Senator, my personal view of the Voting Rights Act was not something somebody was interested in. You have people who serve on your staff, and their job is to help you implement your views as a senator.
I'm not questioning what your view was then. I'm asking what you think now, having, and this is a pretty settled area, I think you'd agree. Having seen all this, having been intimately involved in it, knowing it as well as you do you believe that the intent test was still the more appropriate standard by which to evaluate vote dilution claims?
Senator, I haven't studied the Voting Rights Act to determine whether the intent test or the effects test would have different results in different cases under Section 2. I'm in no position to make a judgment on that.
It would be my sense that you would be a person who would, with your enormous abilities and background, to have some sense about that. I obviously understand that requiring a voter to prove any additional factor makes it harder for the voter to win the case, and that to prove the intent of an entire legislative body can be very difficult, especially when a voting system was put in place many years ago, right, requiring African Americans and Latino voters, many of whom have had limited financial resources, to find evidence of intent was adding an enormous hurdle for them to overcome. And the Mobile versus Bolden case itself, which was pursued after the Supreme Court's decision in 1980 and before Congress amended the law in 1982, makes it very clear, I think clear to all of us over the years, how difficult that standard was. African Americans from Mobile, Alabama have been unable to elect any candidates to the position of city commissioner for every election cycle for something like 7 decades. They challenged the method of electing city commissioners that allowed the same majority to choose all the commissioners all the time in at-large elections. And the evidence was very clear that as a practical matter, although African Americans could register and vote, they couldn't elect anyone. But to get relief under the Supreme Court standard, which you appeared to have supported, they had to go to enormous effort and financial expense to prove discriminatory intent, including hiring a historian who could piece together the motivations of city officials who had designed the electoral system almost 100 years earlier. In this situation, the administration was not bound by a Supreme Court decision in deciding what position to take on the proposed Voting Rights Act's amendment. So why at that point did you want to make Section 2 cases so difficult to prove?
Senator, you keep referring to what I supported and what I wanted to do. I was a 26-year-old staff lawyer. It was my first job as a lawyer after my clerkships. I was not shaping administration policy. The administration policy was shaped by the Attorney General on whose staff I served. It was the policy of President Reagan. It was to extend the Voting Rights Act without change for the longest period in history at that point. And it was my job to promote the Attorney General's view and the President's view on that issue. And that's what I was doing.
I recognize that. What I'm trying to figure out is, given the fact that you followed this issue for such a long time, I would think you would have a view at this point about whether you were right about, or the department, let's say, since you were working for them, whether the department was right on seeking to keep the intent test, or whether time has shown that the effects test is really the more appropriate test.
Well, Senator, I haven't followed the issue of the particular litigation. I was involvement in some litigation when I was in the Solicitor General's office, in which we were effective in proving violations under the Voting Rights Act. Many of those cases arose under issues under Section 5, preclearance issues, and not under Section 2. I, as a judge, had a case, three-judge district court case, again arising under the preclearance provisions. But I'm certainly not an expert in the area and haven't followed and have no way of evaluating the relative effectiveness of the law as amended or the law as it was prior to 1982.
Well, with all respect, I realize I should move on to another topic, but it just seems, given how strongly you stated some of these memos, and I understand you were doing your job, I would think you'd have a view today whether or not those strong statements still make sense. But let me move on. As you know, 42 U.S.C. 1983 is a federal law that allows Americans to sue those who deprive them of their rights under the Constitution or federal statutes. Section 1983 is a very important law because it has enabled individuals who are deprived of their rights to such things as Medicaid, public housing, child support enforcement, and public assistance to enforce those rights in federal court. And I'm a little concerned that you seem to consistently argue for making it harder to bring Section 1983 lawsuits. In briefs you filed, you advanced a series of arguments to effectively reverse decades of Supreme Court decisions and restrict Americans' ability to enforce federal statutory rights under Section 1983. As Deputy Solicitor General, you co-authored an amicus brief and argued in favor of the Supreme Court and in front of the Supreme Court in a case called Wilder versus Virginia Hospital Association. You said that individual Medicaid providers should not be able to sue under Section 1983 to enforce a provision of the Medicaid statute which requires states to reimburse them for services at reasonable rates. One of the arguments you made is that in order for a statutory right to be enforceable under Section 1983, the court must find that the Congress clearly intended, quote, to authorize private enforcement of that right in federal court, unquote. You repeated this argument in another case you later argued when you were in private practice, Gonzaga University versus Doe. The Supreme Court rejected your arguments in Wilder and found that the Medicaid providers could sue. In the later Gonzaga case, the Supreme Court specifically rejected your argument and found that it was not necessary for plaintiffs in a 1983 case to show that Congress intended to create a private right of action to bring a lawsuit, since Section 1983 already supplies a cause of action. What role did you play in deciding that the government would participate as amicus in the Wilder case? And what role did you play in developing the argument that it made? And did you agree with the position that the government took in the case?
Well, I'll answer the question, but before I do so, the position I advanced in the Gonzaga case prevailed. The argument that we made on behalf of the university, I was obviously representing the university's position, and they prevailed before the Supreme Court. In the Wilder case, the determination to participate as an amicus was made by the Solicitor General, and I don't recall a particular role in that case. I worked on the brief. I presented the argument. We lost that case 5-4. It was a close issue. All of these issues go to the question of what Congress intended to do. If Congress had spelled out whether or not a right should be enforceable in court, that is what the determination would be in court. These issues arise only because of confusion over whether or not Congress has spelled out that a right should be enforceable in federal court for damages or not. And in the Wilder case, the court determined 5-4 that the right should be enforceable in federal court. We were, as an amicus, supporting one of the states. I don't remember which one it was, and the state was making the argument that there is the right is the issue in all of these cases is whether the right should be enforceable administratively as opposed to with the private
Excuse me, Judge, I'm about to
action.
run out of time. Let me point out the Supreme Court did not accept the argument that the plaintiffs had to show that Congress intended to create a private right of action. And I'm wondering now, do you now agree with the argument that you've consistently made, both as a government lawyer in Wilder and while in private practice in Gonzaga, that individuals should not be able to sue under Section 1983 to enforce a right unless the Supreme Court finds that Congress clearly intended to authorize private enforcement of that particular right in federal court?
Well, the Gonzaga decision, which resulted, there were various arguments made in the brief. The ruling of the court was in favor of the university that I was representing, and the determination in the Gonzaga case about what should be shown and what has to be shown is one of the precedents of the court that I would follow as any other, consistent with rules of stare decisis. That's not an area in which I have any particular view. I've argued both sides of that issue on behalf of plaintiffs, argued in favor of it, and on behalf of defendants against it. Again, the issue is not the enforceability, as in Gonzaga. The issue was, should individuals be allowed to bring suit, as opposed to action by, in that case, the Department of Education.
Thank you for your answers, Judge Roberts.
Thank you, Senator.
Thank you, Senator. Thank you, Senator Feingold. Senator Graham.
Thank you, Mr. Chairman. I imagine the reason that you argue different positions is because people paid you. Is that correct?
That's how I made my living, Senator.
Yeah, okay. I can relate to that. I imagine it must be very hard to figure out what Congress intends. Do you agree with that?
Sometimes it's easier than others,
Yes.
and sometimes it's hard to read the tea leaves.
I can relate to that also. I want to read an excerpt from the National Association of Women Lawyers and their evaluation of you. 8/30/05, as a lawyer and judge, based on interviews the committee conducted, Judge Roberts has treated individual women lawyers fairly and with respect, has fostered careers of women lawyers, has been helpful in enabling women to address work-life balance issues while advancing professionally, and has been consistently described as respectful to female colleagues, female lawyers appearing before him, and female employees. You've been asked about every case, I think, ever written by anyone. I would like to talk to you a little bit about life. The idea of judging you based on this section of the Commerce Clause and that section of the Commerce Clause is important, but I think most Americans want to know a little bit about you. And from what I can tell, the people who've worked with you and against you generally like you, and that you've been described as brilliant, one of the best legal minds of your time, well qualified. The adjectives go on, and I want the record to reflect that comes from people who know you the best. The best indication of a good lawyer is how people on the other side think of you, and we'll get some excerpts from the record to put that into the record. Apparently, from what I can tell, you've conducted your life in a noble, honorable manner, that you've been a good litigant, and that you have fought for your causes, and you've done so to earn respect of those on both sides of the aisle. But there's a greater issue here about who you are. Justice Rehnquist was your mentor, is that correct?
He's certainly someone from whom I learned a great deal, yes.
Okay. So if I was trying to figure out who John Roberts is and a little bit about him, I'll ask this question. Write the legacy of Justice Rehnquist for a minute or two. What would you say if given that task?
Well, I think if you were able to ask him, he would talk about being a grandfather, being a father,
I'm asking you,
being
not,
a husband.
I'm asking you.
But the important point is that those were important things in his life, and he appreciated the need to recognize that those are the most important things. With respect to the law, to which he devoted his professional life, I think a big part of the legacy that he leaves is a Supreme Court in which all of the members respected and admired him because of his fairness in administering the court and conducting the important responsibilities like managing the conference and assigning opinions. You can go back in history and look at what other Chief Justices did. Some were, in terms of that administrative responsibility, some were disasters. You look at Harlan Stone, his idea of running the conference, he said what he thought. Then the next senior justice said what he thought. Then Justice Stone critiqued that. Then the next justice, and then Justice Stone critiqued that. And the result was the conferences went on for days, and everybody ended up hating each other.
So he ran a good ship. I think we all agree with that, and his colleagues respected him, whether they disagreed with him or not. But the basic question is, when you write about the legacy of a Supreme Court justice, you write more than about being a grandfather and more about running a tight ship, especially Chief Justice. Would you agree with the idea that from a conservative point of view, he was the gold standard?
I think he was a very effective advocate on the bench for a view of the Constitution that is one of limited and separated powers.
Do you share that view?
I do. I think that now, I have to tell you that whether as a judge on the Court of Appeals or if I am confirmed on the Supreme Court, I will certainly be my own man, and there are...
No one's doubting that. No one's doubting that you will not try to be fair. But the big theme, 30,000-foot view of you, is that when you look at Judge Roberts, you're looking at someone in the mold of a Rehnquist. Is that a fair assessment?
Well, you know, I admire the late Chief Justice very much, and but I will have to insist that I will be my own man, and I hesitate to be put in anybody's mold, and I would certainly approach the cases according to the judicial philosophy that I have developed over the years. In many respects, it's similar to his in its recognition, I think, of the limited role that judges should have, an appropriate modesty and humility, a recognition that...
The idea of a dramatic departure under your watch from the Rehnquist era is probably not going to happen. Is that true?
Given my view of the role of a judge, which focuses on the appropriate modesty and humility, the notion of dramatic departures is not one that I would hold out much hope for.
Now, I know people don't like being labeled, put me in that category, but I'm in a business where people label me all the time. And but I ask for it. I run for office. But we do tend in our business of politics to try to label people, particularly when we're talking about judges. When the President introduced you to the United States, to the people of the United States, he said you were a strict constructionist. Do you know what he meant by that and why he chose to use those words?
Well, I'd hope what he meant by that is somebody who's going to be faithful to the text of the Constitution, to the intent of those who drafted it, while appreciating that sometimes the phrases they used, they were drafting a Constitution for the ages, to secure the blessings of liberty for their posterity. They were looking ahead, and so they often used phrases that they intended to have effect.
Does that term make you feel uncomfortable?
No.
Right. Now, from a 30,000-foot view of things, it seems to be that we're going to have a referendum on the Reagan era here, which I welcome. I sort of enjoyed it. He won 49 states. He did pretty good. You were part of the Reagan era as a young lawyer. When I use the term Reagan Revolution, what does it mean to you?
Well, it means to me generally a change in attitude. President Reagan always presented an optimistic view. He always told us that the best days of our country were ahead of us. And he reasserted basic fundamental truths in areas like foreign relations. We were going to stand up to the Soviet Union. We're proud of our system of government. That's the right approach, not the Soviet approach. And people who've come of age after the Berlin Wall has fallen sometimes don't understand what it meant at that time.
When it comes to the law, what does the term Reagan Revolution mean to you?
I think it means a belief that we should interpret the Constitution according to its terms, that judges don't shape policy, that judges interpret the law, and that legislators shape policy. The executive branch executes the law.
Does it also mean that when you talk about affirmative action and you set up a quota system, that's not right?
President Reagan's policy was opposed to quotas, which were much more rigid at the time. People need to appreciate 24 years ago the idea of a quota was a rigid set-aside. We now have the recent Supreme Court decisions talking about consideration of particular factors as one factor in an affirmative action program. President Reagan was in favor of affirmative action, and he was opposed to quotas.
When it comes to voting rights, as I understand, and we've talked a lot about it, and we probably know more than all of us ever dreamed we would know about the Voting Rights Act, that you are implementing a policy of President Reagan that wanted to pass the Voting Rights Act in its form that you received. Is that correct?
The proposal was to extend it for the longest period in history without change.
And we've been through a long discourse about the effect and intent test I think you've explained yourself very well that the Supreme Court in the Mobile case said the intent test applies to Section 2. Is that right?
Section 2.
But politics took over after that, didn't it? Because the effect test no longer, that's not the test. Isn't it some compromise between Senator Kennedy and Senator Dole?
There was a compromise in the test under Section 2, which is articulated in a paragraph describing what the criteria are, and including a caution that this should not be read to promote proportional representation, which was some of the concern that the Attorney General and President Reagan had.
So between Dole, Senator Kennedy, and President Reagan, a new test was called the totality of the circumstances?
Yes.
Now, when you said that you, Senator Kennedy said something I thought was very important, that courts should not stand in the way of elected officials who are trying to right wrongs. And the point I'm trying to make here is that you were picked by a conservative president because you have associated yourself with the conservative administrations in the past, advising conservative presidents about conservative policies. And there's another selection to be made, and you're going to get the same type person. And you can, I'm not even talking to you now. To expect anything else is just unfair. I didn't expect President Clinton to pick you. Not because you're not well qualified, not because you're a good person, just a different political, legal philosophy. Now that's what we're going to have to come to grips with here. Justice Scalia, do you consider him conservative?
Yes.
Do you think you're more conservative than he is?
Oh, I don't know. I mean, I wouldn't...
Well, he got 98 votes. And I think you're conservative, but I think you're one of the great minds of our generation, of our time. And I'm dying to find out if you get any votes on the other side. Time will tell. Let's talk about righting wrongs here. I think it stinks that somebody can burn the flag, and that's called speech. What do you think about that?
Well, we had the Flag Protection Act after the Supreme Court concluded that it was protected speech.
Show me where the term symbolic speech is in the Constitution.
Well, it's not.
It's not. They just made it up, didn't they? Now, I think it stinks that a kid can't go to school and say a prayer if he wants to voluntarily. What do you think about that?
That's something that's probably inappropriate for me to comment on.
What do you think Ronald Reagan thought about that?
His view was that voluntary school prayer was appropriate.
I think it's not right for elected officials to be unable to talk about or protect the unborn. What do you think about that?
Well, again, Senator, these are issues that are likely to come before the court, and I can't comment on those particulars because
why are judges more capable of protecting or talking about the unborn than elected officials?
Well, again, those are issues that come before the court on a regular basis in particular cases, and if whether on my current court or the future court, I need to be able to approach those cases with an open mind and not on the basis of statements I make during a confirmation hearing.
The point is that righting wrongs is a very subjective thing. And you will be asked to decide the fate of people with individual needs and individual desires based on particular fact patterns and legal briefs. I'm confident you can do that and that you will do that. And I don't think you need to make a bargain with me to right all the wrongs that I see in life to sit on the Supreme Court. What's it like to go through the nominating process in 2005 from a personal point of view? I've been watching television, channel flipping, and I see some awful things said about you. Have you seen those things?
I've seen some things, yes.
How does that make you feel?
Well, some of the mischaracterizations, you know, you get annoyed at them. I don't like them. Some of the things you see, you get pretty upset about.
How does it make your family feel?
I would say they get upset about some of the things as well.
But you know it's a free country, and that's just the way it is, right?
It is, and it's an expression I've been using a lot lately. It is a free country, and it's a good thing that it is.
Well, let's not talk about you now, but I would like you to comment to us, give us some advice here. We're always trying to advise the President through you. What's the long-term effect on the quality of candidates that we'll be able to recruit for jobs like the Supreme Court if the current process continues and grows over time?
I think it is a very serious threat to the independence and integrity of the courts to politicize them. I think that is not a good development to regard the courts as simply an extension of the political process. That's not what they are. I've been fortunate for the past 2 years to serve on a court in which all of the judges, and they come, the D.C. Circuit, they come from very active careers in public life, sometimes very identified politically, but it's a court where those judges put aside those ties and those views and become judges, all focused on the same mission of vindicating the rule of law. And if you look at the decisions on the D.C. Circuit, you'll see that we are almost always unanimous. We almost always come out the same way, and to the extent there are disagreements, they don't shape up along political lines. That is an ideal, but the more and more that the process becomes politicized, the less likely that that's going to happen.
Another line of inquiry that's been disturbing to me is that we talk about the clients you represent, whether it be the Ronald Reagan administration or some private sector client, and we tend to hold that maybe unpopular position against the lawyer. There's more and more of that happening. We've had Court of Appeals nominees that were accused of being insensitive to the disabled population when they won their case 9-0 in the Supreme Court, defending a university from the idea that they were not covered under the Americans with Disabilities Act. I really do worry that in the future, that if we up here start holding who you represent against you, in the future will pass on the hard cases. What's your thoughts about that?
You know, it's a tradition of the American bar that goes back before the founding of the country, that lawyers are not identified with the positions of their clients. The most famous example probably was John Adams, who represented the British soldiers charged in the Boston Massacre. And he did that for a reason, because he wanted to show that the revolution in which he was involved was not about overturning the rule of law, it was about vindicating the rule of law. Our founders thought that they were not being given their rights as under the British system to which they were entitled. And by representing the British soldiers, he helped show that what they were about was defending the rule of law, not undermining it. And that principle, that you don't identify the lawyer with the particular views of a client or the views that the lawyer advances on behalf of a client, is critical to the fair administration of justice.
Do you believe it's being eroded?
I do think there is an unfortunate tendency to attack lawyers because of the positions they press on behalf of clients. And I think that's unfortunate.
I'm going to give you some examples of a sitting Supreme Court justice and her positions, and basically take us back to the good old days where you could have what I think are extreme positions and still make it. Are you familiar with the ACLU?
Certainly.
In the conservative world, how does that rank on the food chain?
I don't know that I could comment on that. They have a consistent position of promoting civil liberties and a particular view
If you came to the Reagan administration and the top thing on your resume was the general counsel for the ACLU, do you think they would hire you?
I might make it a little harder.
Yeah. I think that's a good observation. Well, we have on the sitting Supreme Court now the former General Counsel for the American Civil Liberties Union, who is a very nice lady, extremely qualified. I don't agree with her hardly at all, but a great lawyer. She has written that the age of consent for women should be 12, that all prisons to have gender equality, men and women should be in the same prison because when you separate them, women prisoners somehow are discriminated against. She wanted to do away, or argued the idea that Mother's and Father's Day should be done away with because it stereotypes men and women. That there's a constitutional right to prostitution. I can give you, and I'll introduce into the record, writings from her point of view that most conservatives would find totally unacceptable. But this person, this lady, the former ACLU executive counsel, is sitting on the Supreme Court, and she got 96 votes. She said that there should be federal funding for abortion. 90% of our caucus is pro-life. Is that about right? Pretty close? I can assure you that if a Republican was going to make their vote based on abortion thinking, she'd have gotten no votes. Most Americans don't want federal funding of abortion, even though they're divided on the issue of a woman's right to choose. She has argued that the Equal Protection Clause guarantees a right to abortion. Now, I completely differ with that, and I'm sure the conservatives in the Senate at the time of her confirmation completely differed with that. The idea of the age of consent should be 12, that bigamy statutes are discriminatory to women. I can go on and on and on, and the point I'm trying to make is that all of that was put aside. Who she represented and what she believed and the position she took, and somehow back then they were able to see in Justice Ginsburg a well-qualified, brilliant legal mind, and they deferred to President Clinton because he won the election. Whether that happens to you, I don't know, but for the sake of the country and the rule of law, I hope it does. I hope you can be in the ballpark of where she wound up. Last two questions. In your opening statement, you articulated the rule of law in a way that I thought was just outstanding. It was emotional. It made sense. Average people could understand it. That the courtroom is a quiet place, Judge Roberts, where you park your political ideology and you call the balls and you call the strikes and you try to give every American a fair shake and you put politics in its perspective. What is your biggest concern, if any, about the rule of law as it exists in America, and what are the biggest threats to the rule of law as we know it today?
Well, you know, the rule of law is always vulnerable because the Supreme Court, as has been pointed out often in history, has only the persuasive power of its opinions to command respect. There have been famous episodes in the past. President Jackson, Chief Justice Marshall has given his opinion. Let's see him enforce it. Other episodes of that sort. But over time, the legitimacy of the Supreme Court has been established, and it's generally recognized across the political spectrum that it is the obligation of the court to say what the law is, and that the other branches have the obligation to obey what the Supreme Court says the law is. The one threat, I think, to the rule of law is a tendency on behalf of some judges to take that legitimacy and that authority and extend it into areas where they're going beyond the interpretation of the Constitution, where they're making the law. And because it's the Supreme Court, people are going to follow it even though they're making the law. The judges have to recognize that their role is a limited one. That is the basis of their legitimacy. I've said it before, and I'll just repeat it myself. The framers were not the sort of people, having fought a revolution to get the right of self-government, to sit down and say, let's take all the difficult issues before us and let's have the judges decide them. That would have been the farthest thing from their mind. The judges had the obligation to decide cases and the authority to interpret the Constitution because they had to decide cases, and they were going to decide those cases according to the law, not according to their personal preferences. Judges have to have the courage to make the unpopular decisions when they have to. That sometimes involves striking down acts of Congress. That sometimes involves ruling that acts of the executive are unconstitutional. That is a requirement of the judicial oath. You have to have that courage, but you also have to have the self-restraint to recognize that your role is limited to interpreting the law and doesn't include making the law.
What would you like history to say about you when it's all said and done?
I'd like them to start by saying he was confirmed.
That was too easy.
Whether they say that or not, I would like it, the answer is the same. I would like them to say I was a good judge.
Thank you very much. I have no further questions.
Thank you very much, Senator Graham. Senator Schumer?
Thank you. Thank you, Mr. Chairman, and thank you, Judge. It's been a long day, and I guess we have a little bit longer to go. But you've been talking something about baseball. We've been talking about it this morning. I'll start out by pitching you something of a softball, an issue, I think, on which reasonable Americans can agree. And those are the recent and abhorrent attacks on the federal judiciary. Many Americans have become concerned that the judiciary has come under escalating, and many would say inappropriate and unjustified criticism from certain quarters. Not just criticism of the legal reasoning, but it goes way beyond that. The rhetoric gets pretty hot. And as you know, one of your mentors and our late Chief Justice, Rehnquist, was a passionate defender of the independence of the judiciary. I didn't agree with him on a whole lot of things, but I sure respected that. And he did a good job both with our committee and everywhere else making sure that happened. So you will be Chief Justice. We haven't talked about your role much here as Chief Justice, the leader of the courts, the head of the judiciary, and I think one of your important roles is to defend the independence of the judiciary. So I'm going to read you a few statements that were made about federal judges in recent months. Televangelist Pat Robertson claimed that, quote, an out-of-control judiciary is the single greatest threat to democracy, unquote, that judges are creating a, quote, tyranny of oligarchy, unquote, and that the threat posed by the federal judiciary is, quote, probably more serious than a few bearded terrorists who fly into buildings. Do you find that, do you disagree with that statement?
I do disagree with that conclusion, Senator. I think it's perfectly appropriate for people to criticize decisions of judges. That comes with the territory. It's a healthy thing. That type of criticism and analysis, saying the judge got it wrong, the court got it wrong, is healthy and good. And the only thing I would say is I'm not sure whether that criticism is along that lines, but personal attacks on judges for doing their best to live up to the judicial oath, that is something that I don't think is
well, isn't this language, I'm asking you about this language, this doesn't seem to be a legal didaction about a court case. When somebody says judges are probably more serious, the threat posed by federal judges is, quote, probably more serious than a few bearded terrorists who fly into buildings. Isn't that kind of, quote, abhorrent and inimical to our system?
I don't agree with that. All I'm saying is that I think people have a right to be critical of judges, but attacks on judicial independence are not appropriate, because judges, and certainly even judges with whom I disagree on the results or particular merits, they should not be attacked for their decisions. The decisions can be criticized, but attacking the judges, I think, is not appropriate.
Would you be a little stronger than that in terms of
Well,
language like this? I mean, not appropriate is kind of mild in these kinds of sort of inflammatory type statements about the judiciary that you may soon be entrusted with protecting.
Senator, I've said, I said yesterday that if confirmed, I would be vigilant to protect the independence and integrity of the Supreme Court and the judicial branch, and that is true. An independent judiciary is one of the keys to safeguarding the rule of law. Again, I said that yesterday, and I believe that. And to the extent the judiciary is attacked, I will be vigilant to respond and defend it.
Let me read you two more and just tell me how you'd characterize them. Conservative lawyer and author Edwin Vieira suggested that Justice Kennedy, a appointee of Ronald Reagan, ought to be impeached for his decisions, and quoted Stalin's infamous problem-solving solution of, quote, no man, no problem. And Tony Perkins of the Family Research Council said, quote, the court has become increasingly hostile to Christianity, and it poses a greater threat to representative government more than anything, more than budget deficits, more than terrorist groups. Do you strongly disagree? Don't those statements turn your insides a little bit?
You know, again, I don't agree with them. But it's a free country. They're free to say what they wish. But the issue of impeachment was resolved in the Salmon Chase hearing. The basic principle was established. You don't impeach judges if you disagree with their decisions. That's not what the impeachment provision is for.
Take it and just answer. If you became Chief Justice, you would do whatever you could to dispel these kinds of notions and oppose people who said things like this when they say these things?
Well, I would do what I can, Senator, to make clear to people, and I do think it's an important educating function, that what judges do promotes the rule of law, and that the rule of law preserves liberties for all Americans. I'm obviously not going to infringe anybody's First Amendment rights. People are free to say what they are.
I'm asking just your First Amendment opinion of these kinds of things, and the most, I guess you said, is you disagree.
Well, Senator, people from all across the political spectrum have attacked judges. They do it now. I've seen some very virulent attacks from all over the political spectrum, and certainly throughout history. Again, judges can stand the criticism of their opinions, but personal attacks, I think, are beyond the pale.
Right. Okay, I'd like to go over some other things here. I have to say I've been pleasantly surprised by some of your answers today. As you know from our private meetings and my opening statement yesterday, my principal concern is ensuring that we don't have people on our court who will dismantle the structural protections that have guaranteed our most fundamental constitutional rights. And what troubles me, and why I think many people are bothered by this right now, is that the President has openly stated that nominees will be chosen in the mold of justices who have stated repeatedly their desire to roll back the clock on some of these basic protections. In my view, over the past 60 or 70 years, maybe longer, three legs have sustained our constitutional rights. The 14th Amendment's guarantees of equal protection and substantive due process, the right to privacy, and a broad delegation of authority to Congress to pass legislation, usually under the Commerce Clause, necessary to protect our nation's security, the environment, Americans' health, and workers' civil rights. On these first two, you have given answers that I think show that you want to protect those rights, and I just want to repeat them and just make sure that you're on the record for them. To Senator Biden, he asked, do you agree there's a right to privacy to be found in the Liberty Clause of the 14th Amendment? And you responded, I do, Senator. Liberty is not limited to freedom from physical restraint. It does cover areas, as you said, such as privacy, and it's not protected only in procedural terms, but it's protected substantively as well. That accurately states your view.
Yes.
And on the Griswold case and the right to privacy there, you said in reference to Senator Cole's question, quote, I agree with the Griswold Court's conclusion that marital privacy extends to contraception and availability of that. The Court since Griswold has grounded the privacy right discussed in that case in the liberty interest protected under the Due Process Clause. That is your accurate view. Okay. Just one question. I know this could take the rest of our time, but if you could answer it succinctly. Just tell me how, I'm interested in how you will divine what that right to privacy means. I mean, this is going to be an issue in the 21st century that's before us in many, many different ways. And there's no words in the Constitution.
Well, the court in, for example, I think most recently in the Kluxburg case, talked about the necessity of considering the nation's history, traditions, and practices. As Justice Harlan always explained in his opinions, you need to do that with an appropriate sensitivity to the limitations on the judicial role. Again, you need to recognize that it is not your job to make policy, either under the Constitution or under the statutes. You are interpreting the Constitution, and the appropriate judicial role focuses on those considerations, tradition and history and practice, as developed in the Court's precedents. And that's where I would start. In any case where the issue came up, it's whether or not a particular issue was presented under the Due Process Clause. You begin with the precedents. You analyze them under principles of stare decisis, the precedents in this area, just like precedents in any other area, and analyze them in light of those different factors. All the justices recognize that in this area they are you need to be especially careful about the source of the content that you're giving to the right at issue, because it is an area in which the danger of judges going beyond their appropriately limited authority is presented because of the nature of the sources of authority. You're not construing the text narrowly. You're not looking at a particular statute with legislative history. All of the justices who have recognized that it presents particular challenges.
Right. Okay. Thank you. Now, as I said, there are a few things that I think many of us were pleasantly surprised about. There are some that we are troubled about. I think you've answered some questions, but not answered a whole lot of others, and I'm going to get into that at another point. But I do find it very perplexing, and I'm not going to ask you to comment on this, your use of the so-called Ginsburg precedent. It seems you cite it when you don't want to answer something, but a few times here, when Ginsburg had actually answered those specific questions, you didn't want to answer them, and you ignored the precedent. And I don't think that's what precedents are, even in this more unique role. So I hope you'll think about that overnight, because I'll get back to that tomorrow. The other thing that troubled me was the issue of civil rights. Many of us consider racism the nation's poison. De Tocqueville wrote about that since 1832. And we know you wrote these series of memos 20 to 25 years ago. Some of them are written in a tone that suggests you may have been insensitive to discrimination and hostile to equal rights. And I've talked to people who might have felt just that. People have said that. So my question is not the substance, but do you regret the tone of some of these memos? Do you regret some of the inartful phrases you used in those memos, a reference to illegal amigos in one memo?
Well, Senator, in that particular memo, for example, it was a play on the standard practice of many politicians, including President Reagan. When he was talking to a Hispanic audience, he would throw in some language in Spanish. There's, again, the memos were from me to Fred Fielding. I think Mr. Fielding always found the tone.
Don't regret using that term. Could you think that some people might find it offensive?
It was meant to convey the notion, again, as I've described, that when politicians speak to a particular audience in that language, is that offensive to the audience? It was meant to convey that. It was an issue concerning a particular radio interview. You know, the tone was, I think, generally appropriate for a memo from me to Mr. Fielding, and I know that he never suggested that it was anything other than
I'd have to disagree with you, but we'll leave it at that. On a more substantive level, in light of where we are in 2005, admittedly we've progressed in civil rights since 1982. Can you identify any policy or piece of legislation you argued for or supported in the Reagan era that you now believe went too far, that you now believe would not be good enough for America? I'm not challenging that you were representing somebody else then, as you've said to us before, but I'm asking, in hindsight, it's now 2005, you're almost double the years on this earth. Any of those policies that you think now, using hindsight, shouldn't have been done?
Well, Senator, I think some 80,000 pages have been released of memoranda that I wrote.
You can just pick one or two.
Well, I don't, you know, I have not gone back and reevaluated all of those policies. No, I do know, though, for example, in the area of civil rights, people have talked about memos I wrote about the administration's policy against busing or the administration's policy against quotas. Being against busing and being against quotas is not the same as being against civil rights. President Reagan was against busing. President Reagan was against quotas. But he was in favor of civil rights. And that was the administration position that I was advancing in those memoranda.
I understand you were advancing someone else's position. I was asking your own view if there were any regrets or changes in viewpoint of you personally, but we'll leave it at that if you don't want to mention any. Okay, I'd like to go to the third leg of protection now and probably spend the rest of my time on this, constitutional rights, the Commerce Clause. Now, just to briefly encapsulate, you've said this, you agree with that the Constitution gives the Supreme Court the power to review and invalidate acts of Congress as was held 2 centuries ago in Marbury versus Madison.
Yes.
And you also said in questions, I guess, with Senator Kennedy, that you agree with the Court's conclusion that segregation of children in public schools solely on the basis of race was unconstitutional, as in Brown. Okay, well, there's a third case that I'd like to bring up, and it's the third leg of the framework in a lot of ways, and that's Wickard v. Filburn. Do you agree with the principle that the Congress has the power under the Commerce Clause to regulate activities that are purely local, so long as Congress finds that the activities, quote, exert a substantial economic effect on interstate commerce? In other words, can Congress regulate commerce that doesn't involve an article traveling across state lines?
Well, that's obviously the Court's holding in Wickard against Filburn and reaffirmed recently to a large extent in the Raich case. But I would say that because it has come up again so recently in the Raich case, that it's an area where I think it's inappropriate for me to comment on my personal view about whether it's correct or not. That's unlike an issue under Marbury versus Madison or Brown versus Board of Education, which I don't think is likely to come up again before the Court. This was just before the Court last year. And so I should, I think, avoid commenting on whether I think it's correct or not.
This is not a recent case. This is Wickard v. Filburn. It's from 1942, I guess it was. It's a basic bedrock of our constitutional law, law after law. The civil rights laws of 1982 and 65 and 65 that, let me just, that you talked about previously are based on the Commerce Clause, not necessarily on Wickard.
No, not on
And
Wickard.
I understand, but so much of what we do is based on the Commerce Clause, and you know that there's a movement to greatly cut back on the Commerce Clause, led by Professor Epstein, one of the justices that the President said he wanted to appoint more justices like. Justice Thomas doesn't really believe in the holding of Wickard. And at a time with Hurricane Katrina, in the midst of the war on terror, where we need a strong national government, I find it, I'm not asking you, there's been a holding that's been accepted, and it was accepted in Raich as well, by just about everybody, with a few exceptions I mentioned, that says you don't need the article to cross state lines to be regulatable under the Commerce Clause by the federal government. That seems to me to be as little in dispute as Griswold, as Brown, in terms of its broad acceptance, in terms of a term that you've used, in terms of the stability of our government. And I'm really surprised that you are unwilling to simply say, I'm not asking you for all the variations on the theme, but a fundamental bedrock, which is that Congress can regulate, under the Commerce Clause, things that don't cross state lines, is something that's in some doubt.
Well, Senator,
I think, you know, you said that, excuse me, you said that there would be unanimity just about, or close to it, on issue after issue. Obviously, there are dissents. I think Learned Hand in 1958 said he didn't agree with Marbury, but you said you had no problems going along with Marbury. In Brown, I suppose there are still some people who don't believe in Brown, here and there. And here's a bedrock principle, admittedly under attack by what I would call an extreme few, that if we didn't unequivocally back it, not the variations on the theme, but the fundamental principle that Congress can regulate if it doesn't actually, the article doesn't actually cross, that Congress can regulate manufacturing because of its dramatic effect on interstate commerce. And you are unwilling to give Wickard the same status that you give Griswold, which was decided 22 years later, or Brown, which was decided 12 years later. I mean, I know that Morrison and Lopez, but they don't challenge the fundamental precept. I didn't ask you if you fully support Wickard. I asked you if you support the proposition that under the Commerce Clause you don't need the actual article crossing the state line. And you're not willing to say that that's settled law, that that's part of our established way of law.
Well, Senator, all you have to do is look at the arguments, the briefs in the Raich case, where that was the issue that was argued, whether or not Wickard v. Filburn was still good law, whether or not Wickard v. Filburn should be applied in that situation. Nobody in recent years has been arguing whether Marbury v. Madison is good law. Nobody's been arguing whether Brown v. Board of Education is good law. They have been arguing whether Wickard v. Filburn is good law. Now, it was reaffirmed in the Raich case, and that is a precedent of the court, just like Wickard, that I would apply like any other precedent. I have no agenda to overturn it. I have no agenda to revisit it. It's a precedent of the court. But I do think it's a bit much to say that it's on the same plane as a precedent as Marbury v. Madison and Brown v. Board of Education.
Or Griswold?
Or Griswold. The fact that it was just reconsidered and re-argued last year in the Raich case suggests that it's not that same type of case, and that's why I'm uncomfortable commenting on it. I have gone farther than many other nominees in talking about cases like Marbury, like Brown, like Griswold, because of the, I thought it was appropriate, given the fact that those issues are not, in my view, likely to come before the court again. Here's an issue that was just before the court last year, so I can't say that it's unlikely to come before the court again, and therefore I think it falls in the category of cases in which I should tell you I recognize it as a precedent of the court. I have no agenda to overturn it or revisit it, but beyond that, I think it's inappropriate to comment.
Well, I would say that, well, let's go to a few more commerce case issues. Again, I find it, I think Wickard is as accepted, is as part, not Wickard per se, but the idea that crossing state lines is not the only thing that you need for the Commerce Clause, that you don't have to have the article cross state lines to be able to regulate it, is a bedrock of law after law after law that the federal government has passed, and your inability to concede
I'm not expressing any
but
hostility to the proposition at all. All I'm telling you is that this is a case that was challenged, the application in the Raich case last year, and to say that it's in the same category as Marbury or Brown, I think is
right. But sir,
inaccurate.
Griswold came up in Lawrence. I don't know how many years ago that was. You can make the argument that even somehow or other somebody challenged precepts that flow from Marbury. I certainly...
And so perhaps I should have taken the approach Justice Scalia took. He wouldn't tell this committee whether Marbury was correctly decided.
Glad you didn't do that.
Well, and then the reward for not doing that is to have additional cases that are very current in terms of the litigation before the court. And the idea is, well, you said what you thought about Marbury. What do you think about the Raich case, which just reaffirmed Rickard against Filburn? They're two very different parameters. My approach has been a practical one, not an ideological one, but a practical one.
So, but
saying,
I'm sorry. Just explain to me why you can say it about Griswold, which I'm glad you did, but not about Wickard. Both of them have been litigated, tangentially at least, in the last 5 or 6 years.
Well, Wickard was litigated directly in the Raich case. I don't think the issue in Griswold is likely to come before the court. It was unlike.
Isn't Lawrence an outgrowth of Griswold in terms of what the right of privacy is to consenting adults in their bedroom?
Well, that's one of the issues, but the difference between the issue that was presented in Griswold and its ramifications of the analysis, those are two very different issues.
Okay. Let me ask you just a little bit about a little more on the Commerce Clause. We've all talked about the hapless toad and the need, the fact that the toad didn't cross state lines didn't lead you to reject the Endangered Species Act under the Commerce Clause, but go seek another possibility. So let me give you a couple of hypotheticals. Let's say we figured out that somebody could make botulism, or a lot of people could make botulism, a deadly, deadly poison. I think it's one of the 7 poisons that the FBI looks for in terms of doing danger to us. But they could make it with materials completely within the state. There was no material that crossed state lines. It's a little bit like the toad. Would you think that the federal government, if Congress so deigned, would have the ability to regulate that activity?
Well, I think that sounds a lot like the Raich case, where the court determined the medical marijuana issue, even though the regulation of marijuana as an illicit drug, it had interstate impact, even if the medical provision of it did not. And so they were willing to look beyond and apply the Wickard case, which they reaffirmed the suitability, and conclude that that had a significant effect on commerce, the regulation in general. You didn't have to look at the specific regulation. It seemed to me that that
Could you differentiate that from Viejo?
Well, in Viejo, you're dealing with a particular species and the difficulty. And again, it was what another court had looked at not the activity that was regulated, the interference with the species, but the activity that was taking place and having that impact, the building of a housing development. Other courts, the Fifth Circuit in the GDF case, had argued that the approach of looking at the housing development rather than the particular activity was inconsistent with the Supreme Court's decisions. And what I said is that if there's another basis on which to evaluate it, and there was, and the panel opinion noted, we don't have to reach these other grounds because of our conclusion, that we should focus on those other alternative grounds and see if we could base and uphold the Act on those.
I understand. And my time is getting close to the end, so I'm not sure I agree with the large difference between Raich, Viejo, and the hypothetical that I gave. I think the Viejo case and the hypothetical I gave are limited. But let me just conclude with this. And, you know, people wonder, what's all the fuss about? And the answer is very simple, and that is that we could see if certain viewpoints became majority viewpoints on the Supreme Court, the dismantling of the entire apparatus to protect our rights through the narrowing of the Commerce Clause, which I said Justice Thomas already agrees should be narrow, and we have a president who may have, he at least has one more nomination, who said he wants to appoint people in the mold of Thomas. Not only would the Endangered Species Act go, Title VII would go, OSHA would be gone, the Controlled Substances Act and prohibitions against personal possessions of biological weapons could all be unconstitutional. Justice Thomas's views on this issue are similar to others. He's against any substantive due process right under the 14th Amendment. He believes that the Establishment Clause would allow the establishment of state religions, in the states. And so this is these are serious, serious things. He'd invalidate campaign finance laws. He'd eliminate affirmative action. Now, he's just one justice. But I think it's our job here in the Senate, on both sides of the aisle, if we feel that that kind of judicial philosophy, that kind of legal reasoning does not belong in the court, to find out if nominees ascribe to it, and if they do, look at them warily. I'm not saying you do, as I said. Some of the things you said I found pleasantly surprising today. But I do think it's our job, and I think we're going to continue to do it.
Thank you very much, Senator Super. Senator Cornyn.
Thank you, Mr. Chairman. Judge Roberts, I appreciate your stamina hanging in there with us. I particularly appreciate your responding to the call to public service. And I want to say that I would be remiss if I didn't express what I know all members of the committee and the Senate feel is the appreciation for your family and their support.
Senator Cornyn, before you proceed, there's been a request for a short break. So let's take one 5 minutes.
Short 5-minute break here in the Senate Judiciary Committee and the nomination hearing for John Roberts to be United States Chief Justice. Still to come, we will hear from a couple of senators before the committee breaks for the day. John Cornyn, Republican of Texas, he'll get his 30 minutes next. And then Dick Durbin, who is also the Assistant Minority Leader in the Senate, Democrat from Illinois, Dick Durbin. He should be coming up at about 7:15, 7:20. So the committee will break after that, about 7:45, 7:50 or so, and be back tomorrow for a couple more members for round one, which is 30 minutes of questioning. Sam Brownback of Kansas and Tom Coburn of Oklahoma, both Republicans. 18 members on the committee. Most of them had their 30 minutes today in this round one. Tomorrow, in addition to those two senators getting their 30 minutes, a second round, they call it round two, 20 minutes of questioning from all 18 senators. And then the committee will go into closed session to deal with FBI reports about John Roberts. Members are back tomorrow in this room at 9:30 a.m. Eastern Time. Chairman of the committee there on your screen, Arlen Specter. And we'll have it live here on C-SPAN 3, also streaming live online at cspan.org. And you can listen to all of these hearings on C-SPAN Radio, which is on Sirius Satellite Radio and XM Satellite Radio, 90.1 FM in the Washington-Baltimore area. House members at this hour are voting on the floor in the U.S. House on a couple of number of suspension bills that they debated earlier today. And in the Senate, members are currently in a quorum call. They're scheduled for 2 or 3 votes at about 7:30 p.m. Eastern, about 45 minutes from now, dealing with the Commerce, Science, and Justice Appropriations Bill that they've been working on this week. That won't finish this week. That will continue into next week. So the committee back in just a few minutes. And also a reminder that we will be showing all of today's confirmation hearing, nearly 10 hours of it, on our companion network C-SPAN 2 that's scheduled for 9 p.m. Eastern Time tonight.
Did that at the Supreme Court.
We will resume, and the clock has been reset at the full 30 minutes, Senator Cornyn.
Thank you, Mr. Chairman. Judge Roberts, let me start on a couple of items that I think will be relatively non-controversial. Believe it or not, and maybe people watching this proceeding won't believe it, but members of this committee and members of the Senate actually do try to work together on a bipartisan basis to pass legislation that we believe is in the best interest of the people who sent us here and the American people. One area of bipartisan agreement, I just want to reiterate Senator Feingold's comments about cameras in the courtroom. I am a strong supporter of cameras in the courtroom as long as they're unobtrusive and they don't disturb the proceedings or prejudice the rights of the litigants. But I do agree with him that it's important, and Senator Grassley, I know, is each Congress introduces legislation on this. I do believe it's important to let the people of the United States know what happens in courtrooms. I think they could learn a lot about their government. I think that would make them more sensitive to the nature of the decisions that are made there and give them confidence that there are dedicated public servants who serve in the judiciary who are doing the job of a judge day in and day out in a dignified and distinguished and professional manner. Along the lines of what Senator Kyle mentioned earlier, there's another area that I think is non-controversial and bipartisan, but it's something, frankly, that we need your help with if you're confirmed as Chief Justice. And that has to do with the bar to the courtroom presented by excessive costs and time delays inherent in modern litigation. These impediments to access to justice are just as effective as if you had an armed guard at the door of the courthouse or had somebody put a padlock on the front door, because frankly not many people can afford access to the courthouse, to justice, to jury trials, because the costs are just so prohibitive. And I remember that Chief Justice Berger, when he was chief, took on the cause of alternative dispute resolution and this cause of excessive delay and cost as being an impediment to access to justice with quite a bit of success. But it's a cause that needs a lot of work. It needs the attention of the Chief Justice of the United States and the prestige that you would bring to that, because frankly it worries me a great deal. Just like it concerns me that we see with the length of time of modern jury trials. Of course, many people think about jury trials. They think about the O.J. Simpson trial where the jury was impaneled for months on end and wonder how in the world can a jury still represent the conscience of the community and be a cross-section of the community when so many people are precluded from serving because of the economic or other hardship associated with that. So these are hard issues that I hope you will take a look at and work with the Judiciary Committee and the Congress, if necessary, or where necessary, I should say, to try to address, because I think they would be a great service to the American people. Let me, as a good lawyer, you know the danger of analogies. And yesterday we started talking about judges as umpires. And you were quite eloquent in saying that you wanted to be an umpire. You didn't want to bat or pitch. And I think it was a very succinct and appropriate way to describe exactly the role that you thought judges ought to play, not as partisans, but as impartial and disinterested in the outcome, but nevertheless interested in providing access to justice. Well, I happened to be looking at my computer last night, and one of the blogs, and it's always frightening to see, to put your name in a search and look at the ways it's mentioned. I suggest you don't do that if you haven't until this hearing is over, because this hearing is the subject of a lot of activity and interest in the blogosphere. But one of these blogs said that your comparison of a judge to a baseball umpire reminded him of an old story about 3 different modes of judicial reasoning built on the same analogy. First was the umpire that says, some are balls and some are strikes, and I call them the way they are. The second umpire says, some are balls and some are strikes, and I call them the way I see them. The third said, some are balls and some are strikes, but they ain't nothing till I call them. Well, I don't know whether it's a fair question to ask you which of those 3 types of umpires represents your preferred mode of judicial reasoning. But I wonder if you have any comment about that.
Well, I think I agree with your point about the danger of analogies in some situations. It's not the last, because they are balls and strikes, regardless, and if I call them one and they're the other, that doesn't change what they are. It just means that I got it wrong. I guess I like the one in the middle, because I do think there are right answers. I know that it's fashionable in some places to suggest that there are no right answers and that the judges are motivated by a constellation of different considerations, and because of that it should affect how we approach certain other issues. That's not the view of the law that I subscribe to. I think when you folks legislate, you do have something in mind in particular, and you put it into words, and you expect judges not to put in their own preferences, not to substitute their judgment for you, but to implement your view of what you were accomplishing in that statute. I think when the framers framed the Constitution, it was the same thing. And the judges are not to put in their own personal views about what the Constitution should say, but they're supposed to interpret it and apply the meaning that is in the Constitution. And I think there is meaning there, and I think there is meaning in your legislation. And the job of a good judge is to do as good a job as possible to get the right answer. Again, I know there are those theorists who think that's futile, or because it's hard in particular cases, we should just throw up our hands and not try in any case, and I don't subscribe to that. I believe that there are right answers, and judges, if they work hard enough, are likely to come up with them.
Well, as a good lawyer, you also know the danger of an analogy is that people will take it and run away with it, perhaps use it against you. And I heard today that yesterday we were talking about baseball, but today we're talking about dodgeball. Some have suggested that you've been less than forthcoming about your answers to the questions, and I just couldn't disagree with that more. And I want to go over this just a minute, because I think it bears some repetition. First of all, you were confirmed by the United States Senate by unanimous consent just a little over 2 years ago to the District of Columbia Court of Appeals, what some have called the second most important or powerful court in the nation. So you've been before the committee before. You've been thoroughly investigated, examined, and scrutinized, perhaps more than anyone else in history. The reason I say that is because since your nomination first as Associate Justice and now as Chief Justice, there have been more than 100,000 documents produced about your background and record, some in the government sector, some in the private sector. And of course, we've heard today how perhaps a line or a word or a choice of phrase can be used perhaps out of context to try to create an impression that may or may not be borne out by looking at the entire context of your record or even the document. But I do believe you have been forthcoming. I know the before we had the last 2 rounds of questions, you'd answered 35 questions on civil rights, 10 on following precedents. You answered 40 questions about the role of a judge, 25 on abortion and privacy rights, and 11 on presidential powers. So I would just disagree with the characterization that someone might make. I don't think it's fair or accurate that you've been anything less than completely forthcoming, and that we frankly know an awful lot about you, and that's not been a bad thing. I think, from my point of view, the more that we have learned about you, the more confidence many of us have in the judgment of the President in your selection. But of course, you're not there yet. We still have a lot of questions to ask before voting. I want to also talk to you a little bit about one area of questioning. I believe it was Senator Biden who was asking you about Justice Ginsburg and the fact that she answered some questions but declined others. And we've talked about the Ginsburg standard. I think Senator Schumer referred to that as well. And what I understand that to mean, what I mean by that when I say it, is that she has recognized that there is a line that a nominee cannot step over in terms of prejudging cases or issues that may come back before the Supreme Court. And that's the line I understand you to have drawn. But Justice Ginsburg, as I believe Senator Graham pointed out, had an extensive paper trail and record, and she did feel at some liberty to talk about issues where her views were already public or where she had already written. Is that the distinction, or could you explain your understanding of the distinction she was making or how she handled it, perhaps in a way that's different from the way you are handling questions?
My understanding, based on reading the transcripts, not just of Justice Ginsburg's hearing, but of the hearings for every one of the justices on the court, is that that was her approach, that she would generally decline to comment on whether she viewed particular cases as correctly decided or not. She at one point said that that was the court's precedent. She had no agenda to reconsider it, and that was all she was going to say. And in areas where she had written, she thought it was appropriate to discuss more fully because it was an area that she'd already publicly commented on. And I understand that to be the distinction as to why she commented in particular areas but not others.
To your knowledge, is the line that you have attempted to walk in these proceedings about being as forthcoming as you can, but recognizing that you have a responsibility not to jeopardize your impartiality, either the perception or the reality, or the impartiality and independence of the judiciary, is that been the line that you've attempted to walk, and as you understand previous nominees have attempted to walk?
It is, Senator, with an exception, and the exception is that I've tried to share more of my views with respect to particular cases. I know other nominees have declined, for example, to comment on even a case like Marbury versus Madison because they thought as a theoretical matter it could come before the court. I tend to take a more practical and pragmatic approach to things rather than a theoretical or ideological approach. I think as a practical matter, an issue about Marbury versus Madison is not likely to come before the court. The same with Brown versus Board of Education. So I've gone farther than many nominees and have been willing to talk about my views on those particular cases. But I do think when it gets into an area where the correctness or incorrectness or my agreement or disagreement with a particular precedent is in an area that is likely to come before the court or could well come before the court, I do have to draw the line there. And it's not out of any interest to dodge questions or anything. As my views on the cases that I think are not likely to come before the court, I'm perfectly willing to discuss. It's based on the concern that the independence and integrity of the Supreme Court depends upon justices who go there and will decide the issues there with an open mind based on the judicial decisional process, not based on prior commitments they made during the nomination hearing. All of the justices have adhered to that approach for that reason. And if I'm to join their number, I need to be able to look them in the eye in the conference room and say I kept the same faith with the independence and integrity of this court.
Well, I think it also may reflect the fact that you seem to be quite comfortable responding to questions from the committee. You've had a lot of experience responding to questions from the bench and having to distinguish cases, answer hypothetical questions and the like. And I think we have gained an appreciation, a greater appreciation for your for the skills that you've acquired and your ability. But I understand the line you're walking, and I think it's really a constitutional standard that you're trying to observe, and I applaud you for it. A couple other areas I want to ask you about, but first let me ask you this. Judges are not in the business of picking winners and losers before they've actually heard the case. Of course, I mean, that's fundamental to our concept of justice, that a judge be open-minded, be willing to listen to the facts and arguments of counsel, and then make a decision. And the process that you use is by applying neutral principles. In other words, when you make a decision based on the Commerce Clause, or even based on stare decisis, does that really have anything to do with the ultimate result? In other words, do you start with the results you want to reach first and then go back and try to rationalize it or justify it by the way you read the Commerce Clause of the Constitution or apply the legal doctrine of stare decisis?
No, Senator. It's saying a judge is result-oriented, that type of judge, that's about the worst thing you can say about a judge.
Those are almost fighting words.
It's about the worst thing you can say, because what you're saying is you don't apply the law to tell you what the result should be. You don't go through the judicial decisional process. You don't look to the principles that are established in the Constitution or the law. You look to what you think the result should be, and then you go back and try to rationalize it. And that's not the way the system is supposed to work.
Well, I know that we've heard today about a number of terms from stare decisis to pro hoc vice to pro forma to the only one we haven't heard is res ipsa loquitur and a number of other Latin phrases that we learned in law school. But let me ask you about stare decisis. I've heard fascinating discussion back and forth about the precedent and how you would deal with a case, let's for say example Roe versus Wade, and some have suggested, law professors and maybe others, that somehow that's a super precedent, or in the words of our inimitable chairman, a super duper precedent. I think we're introducing new words to the legal lexicon as this hearing goes on. But in all seriousness, well, let me ask you this. Is stare decisis a insurmountable obstacle to revisiting a decision based on an interpretation of the Constitution?
What the Supreme Court has said in the Casey decision, for example, is that it is not in an inexorable command. In other words, it's not an absolute rule. And that's why they have these various cases that explain the circumstances under which you should revisit a prior precedent that you think may be flawed and when you shouldn't. And
excuse me, I didn't mean to interrupt you.
I was just going to say there are significant cases in the court's history, in the nation's history, where the court has revisited precedents like Brown versus Board of Education, like the cases that overruled the decisions of the Lochner era.
Well, and that you started to make the point I was going to try to make, and that is stare decisis did not prevent the United States Supreme Court from revisiting Plessy versus Ferguson, which established the separate but equal doctrine, or otherwise Brown versus Board of Education would never be the law of the land. Stare decisis did not prevent the Supreme Court from overruling Bowers versus Hardwick and Lawrence versus Texas, or Stanford versus Kentucky in this recent term of the court, where they said the death penalty for 17-year-old murderers was unconstitutional in Roper versus Simmons. So would you agree with me, Judge, that this is a neutral principle? In other words, it's not a result-oriented principle, if there is such a thing. You have pledged to apply neutral principles, not result-oriented processes in arriving at your decisions if confirmed.
That's right. It is a neutral principle. The factors that the court looks at in deciding whether to overrule prior precedent or not do not depend upon what the decision is or what area it's in, other than some areas, things we've talked about. For example, a statutory decision is much less likely to be overturned than a constitutional decision, just because Congress can address those issues themselves. But the principles of stare decisis are neutral and should be applied in a neutral way to cases without regard to the substance of the decisions being considered.
And when you said this morning in response to questions about Roe versus Wade that it is settled as a precedent of the court entitled to respect under principles of stare decisis, you were saying that just that. In other words, that it is a precedent of the court. There has to be a strong case made for why that issue should be revisited, if at all. But you weren't making any commitment one way or another about the outcome of any challenge brought under that or any other legal doctrine, were you?
No, Senator. I've tried as scrupulously as possible today to avoid making any commitments about cases that might come before the court.
I agree you have, and I just wanted to make sure that we were all on the same page in that understanding. Senator Schumer asked about the Commerce Clause, and I've just been I've been fascinated by this debate about the Commerce Clause. Of course, you know, when this nation got started, of course, first we had the Articles of Confederation, where the states were supreme, and the nation couldn't function unless all states agreed. And so the federal government was essentially impotent, which led, of course, to the Constitutional Convention and a federal form of government where states and the federal government shared powers. And now it's interesting to hear, of course, we've seen a growth of national power over the years through a series of court decisions. And Congress, frankly, has pushed the envelope and tried to argue that Congress has virtually unlimited power to legislate and can crowd out state governments completely out of any field it wants to. But isn't it true that there are specific jurisdictional bases upon which the Congress can legislate? In other words, under the 14th Amendment, Section 5, under the Commerce Clause. In other words, the Constitution of the United States was supposed to be a constitution of delegated or enumerated powers. And the interstate commerce being one of those enumerated powers. Of course, there are other provisions like the Necessary and Proper Clause. There have been a lot of decisions over the years about whether it's only powers expressed or implied and the like. But isn't it true that the Supreme Court in the last decade has finally said in Lopez and Morrison, for example, that federal power is not unlimited, that there is some limit, and the fight is really over where those limits are? Would you agree with that?
Yes, Senator, and I do think that a proper consideration of Lopez and Morrison has to take into account the more recent Supreme Court decision in Raich, where the court made the point that, yes, we have these decisions in Lopez and Morrison, but they are part of a 218-year history of decisions applying the Commerce Clause, and they need to be taken into account in the broad scope. It's an appreciation, again, the first one in 60, 65, 70 years that recognized a limitation on what was within the commerce power, but they're not they didn't junk all the cases that came before. They didn't set a new standard. That's what the court said in Raich. It said, yes, we have those two cases. Don't overread them. Put them in the context and, move on from there. And as the court in Raich concluded, they upheld the exercise of Congress's authority there.
Well, I don't think it would come as any surprise to anyone who's listening to these proceedings outside of the Beltway that our government was premised in part on the notion that all wisdom does not emanate from Washington, D.C., and that the states do have areas of competence and authority to the exclusion of the federal government. And one of the great things I think about this hearing is that a lot of people, I think, are learning and hearing about concepts and about that perhaps they'd never heard about before. But really, these are debates that have occurred since the beginning of America itself and since the formation of our government. So I hope that this is an educational experience, or maybe even a refresher course for many of us about some basic principles upon which our government was founded. And of course, the most important principle from my standpoint is that articulated in the Declaration of Independence itself, that says that our laws are based on consent of the governed, which means that most of the debates we have about the laws and the policies that will govern us and affect our families and our jobs are going to be decided in the political realm, where people can muster majorities and vote and have laws signed, and people who are in the minority may live to fight another day and turn that law over in the political forum. And that very few cases, very few issues will be completely removed from that political forum. And those are the cases where the Constitution precludes legislative activity. But I very much appreciate your expression of the role of a judge as one having a sense of humility and modesty. That's not to say, from the way I look at it, or I'm sure the way you look at it, that the job of a judge is unimportant. Being a judge is not easy all the time because you have to make tough decisions which may not be politically popular. But that's what goes along with the territory. But I appreciate the distinction that you've made and articulated for us here in preserving the vast majority of the debates and issues that affect each of us in America and our families and our jobs as ones where we can govern ourselves through our elected representatives. And if we don't like the way that our elected officials are deciding things, we can throw the rascals out. But we can't do that when it comes to an appointed lifetime tenured judge on the Supreme Court. And so I appreciate very much the distinction that you're drawing. With that, Mr. Chairman, I'll surrender back 2.5 minutes. Thank you.
Thank you very much, Senator Cornyn. Senator Durbin.
Heck, I thank you too.
Thank you, Mr. Chairman. Judge Roberts, Mrs. Roberts, family and friends, the end is near, at least for this leg of the race. Welcome to night court. I was struck by a question and answer by Senator Grassley to you earlier today. The question was this: well, is there any room in constitutional interpretation for the judge's own values or beliefs? And your response? No, I don't think there is. Sometimes it's hard to give meaning to a constitutional term in a particular case, but you don't look to your own values and beliefs. You look outside yourself to other sources. Judge Roberts, I recently finished a book about Justice Blackmun and his service on the Supreme Court. And it was a fascinating book about his life on the court and his life in the federal judiciary. And I found it interesting that near the end of his term on the court, a couple cases occurred which really spoke to the heart of the man. One was Descheny versus Winnebago County. A poor little boy who had been beaten and abused, left retarded by dereliction of duty by many of the county officials or state officials in Wisconsin, and an effort by his mother to hold them accountable. And they failed in the Supreme Court, but Justice Blackmun wrote a dissent, which he prefaced, "Poor Joshua." And he said at one point in response to someone who wrote him afterwards about the court, "Sometimes we overlook the individual's concern, the fact that these are live human beings that are so deeply and terribly affected by our decisions." The other thing that occurred in Blackmun's legal career, judicial career, was a real change in his view on the death penalty. And I think most of us are aware of the famous statement which he made that, "From this day forward, I no longer shall tinker with the machinery of death." The last case that he voted with the majority on in favor of the death penalty was a case that you were involved in, the Herrera case. You were a deputy solicitor general at that time. It involved the case of an individual in Texas who had been accused of killing 2 police officers, who tried to reopen his case, offering evidence that his brother, who had since died, had actually been the killer. He turned to the federal court because he'd lost his time for reconsideration of the case by Texas law, and he argued a claim of actual innocence. Justice Blackmun, in his statement at the end of this case, said, "Of one thing, however, I am certain. Just as an execution without adequate safeguards is unacceptable, so too is an execution when the condemned prisoner can prove that he is innocent. The execution of a person who can show that he is innocent comes perilously close to simple murder." That was a dissent, or I should say a Blackmun opinion in that case, that addressed your position that you had espoused as Deputy Solicitor General. Did you read that, Blackmun?
Yes, Senator, I did.
Were you struck by the language there? And the reason I ask that question is it's been 11 years since we've had a Supreme Court nominee before us, and a lot of things have happened in relation to the death penalty in America. We've looked closely at defendants who are young, those who are not mentally sufficient to stand trial. And we also now have the issue of DNA. In my state of Illinois, we found 12 people on death row who were innocent people, and a Republican governor pardoned them after the evidence came out. Tell me, in that context, as you look at this and talk about this, what appeared to be a very sterile and bloodless process, as you answered Senator Grassley, tell me what goes through your mind and your heart when you think about addressing the death penalty, what happened in the Herrera case, and what we should look to from the court in the future when it comes to the Eighth Amendment and the death penalty.
Well, I think it's important, first of all, to appreciate that the issue in the Herrera case, I think, was misportrayed as an issue of actual innocence. The issue in the Herrera case is at what point should new claims, in this case, the claim after his brother died, well, guess what? I didn't do it, my brother did it, and he's dead now. That is, to some extent, a claim of innocence, but it's the sort of claim that did not have, as the courts determined there, sufficient factual support to be taken seriously. That's quite different from a claim, for example, of the DNA evidence. Now, that's an issue that's working its way up, and I don't want to comment on it, other than to say that it seems to me that that type of claim, that somebody who just died was the actual murderer, is different from the scientific issue. They're just different cases, so I don't think that one should be taken as suggesting a view on the other. Obviously, any case involving the death penalty is different. The court has recognized that. The irrevocability calls for the most careful scrutiny. It is not an area in which I've had to consider cases as a judge up to this point, and I certainly know the magnitude of the concern and the scrutiny that all of the justices bring to that question. It's just different than other cases. There's no doubt about that. And the DNA evidence, obviously, I think is a very important and critical issue. No one wants an innocent person executed, period. And the availability of that type of evidence, that opportunity in some cases, I think is something that's a very significant development in the law. Now, as I said, there are cases coming up in there, so I don't want to say anything further.
I understand that. It is unfortunate that the decision was made by the White House not to provide the memos and writings on the 16 cases when you served as Deputy Solicitor General. This was one of the cases, Herrera. And so we might have learned a little more about the thinking at that time that led to your conclusion. Let me ask you, I've been here most of the day, and you've been here all day, and I've noted how often you've distanced yourself from the memos written as a 26-year-old staff attorney. And I understand that. That's a long time ago. When we met in my office, that's, I think, exactly what you said when I referred to one of those memos. But I'd like to ask you this. When you were serving in the Reagan administration, the first Bush administration, was there ever a time when you stood up to your conservative colleagues and advocated a position that was more favorable to victims of discrimination or the disadvantaged?
There certainly were internal disagreements and internal disputes about which approach to take, and in many cases I'd be on one side, in other cases I'd be on the other side, certainly. Now, again, those are internal deliberations, but there was debate and disagreement on a regular basis. That's part of the nature of the job.
But there was one case in particular that hasn't been mentioned today that I'd like to ask you about, and that was the case involving Bob Jones University. That was one of the most troubling decisions of the Reagan administration. It was a decision to argue before the Supreme Court that Bob Jones University should keep its tax-exempt status with the IRS, even though it had an official policy that banned interracial dating, denied admission to any applicants who engaged in interracial marriage or were known to advocate interracial marriage or dating. When the Reagan administration took that position, it reversed the position of 3 previous administrations, including 2 Republicans, all of whom argued that Bob Jones was not eligible for this tax-exempt status. This sudden reversal by the Reagan Justice Department, which you were part of at the time, led to the unusual step of the Supreme Court appointing a special counsel, William Coleman, as a friend of the court, to argue in support of the IRS. In 1983, the Supreme Court ruled 8-1 against the Reagan administration and against Bob Jones University. Judge Roberts, there was a heated debate within the Justice Department about whether or not to defend Bob Jones University and its racist policies. More than 200 lawyers and employees of the Civil Rights Division, representing half of all the employees in that division, signed a letter of protest. William Bradford Reynolds, the head of the Civil Rights Division, strongly supported defending Bob Jones. Ted Olson, another person well known in Washington, opposed this defense of Bob Jones. Which side were you on? What role did you play in the decision to defend Bob Jones University policy?
Senator, I was ethically barred from taking a position on that case. I was just coming off of my clerkship on the Supreme Court, which ended in the summer of 1981. Supreme Court rules said that you could not participate in any way in a matter before the Supreme Court for a certain period of time. I think it was 2 years or whatever it was, and it was within that period. This involved an issue before the Supreme Court, so I was ethically barred from participating in that in any way.
The memo that you wrote about the Bob Jones University position, the memo that of December 5th, 1983, that summarized it, leads one to believe in reading it that you were present during deliberations on this policy. Is that true?
No, Senator, I was not involved in the policy because of the bar on participation.
There appears to be another memo, which I'm going to send to you, dated September 29th, 1982, with your handwriting in it, relative to this same issue. And I just, I don't want to surprise you with it. I'll send it to you, and if tomorrow we get a chance, we can revisit it. Let me ask you this. When
Senator Durbin, may we have the numbers there? The staff needs those in order to track them for the record.
This date is dated, September 29th, 1982.
And it has a number on it?
No number, but we'll give you a copy.
Okay,
we'll share it with the judge. I want you to have, this is not a surprise.
Sure.
I just want you to take a look at it. We had a nominee for the Ninth Circuit Court of Appeals, Carolyn Kuhl. Do you know her personally?
Yes.
Served in the Justice Department with her?
Right.
When she came before this committee, Senator Leahy asked her several questions, and she said when she testified, quote, "I regret having taken the position I did in support of the government's change of position on Bob Jones. The non-discrimination principle and the importance of enforcement of civil rights laws by the executive branch should have taken sway and should have been primary in making that decision." I appreciated her candor on that. What is your belief? Was the Reagan administration position on Bob Jones University the right position to take?
No, Senator. In retrospect, I think it's clear the people who were involved in it, as you say themselves, think that it was an incorrect position. I certainly don't disagree with that.
Thank you. Let me move to another topic.
I'm sorry, Senator. I didn't hear the answer.
The answer was no. I don't think it was the correct position to take.
Thank you. Earlier, Senator Feinstein asked you about the separation of church and state, and I would like to follow up on this if I could. She asked whether you believe the separation of church and state was absolute, and I have your answer here relative to the two recent cases on the Ten Commandments. It appears now that there is a debate within the court as to whether or not they will stand behind the Lemon versus Kurtzman standards under the Establishment Clause, the three-part test, which I won't go through in detail. As Deputy Solicitor General of the Bush administration, you co-authored two legal briefs in which you urged the Supreme Court to overrule the Lemon standard, Board of Education versus Mergens and Lee versus Weissman. You argued instead for what has been characterized in shorthand as the legal coercion test. So I'd like to ask you at this point in time, what is your view on the Establishment Clause and the Lemon standard?
Well, the Lemon test is a survivor. There's no other way to put it. When we wrote the brief in Lee versus Weissman, we had a long footnote explaining that I think it was 6 different members of the current court had expressed their criticisms of the Lemon test. They never got together at the same time, and the test has endured. The approach that we were advocating in Lee versus Weissman did focus on the question of coercion and argued that in certain circumstances a recognition of ceremonial religious practices, an invocation at a graduation was the one at issue there, were permissible. And again, I think lost 5-4. And the Lemon test to this day is the test that the court applies. I think one of the justices recently explained, it's not so much how good the Lemon test is that nobody can agree on an alternative to take its place, and there may be something to that. There are cases where the court doesn't apply the Lemon test. It seems to follow a different approach. The great benefit of the Lemon test, the 3-part test that everybody's familiar with, of course, is that it's very sensitive to factual nuances. The disadvantage of the Lemon test, I think, is that it's very sensitive to factual nuances, and you get a situation like with the Ten Commandments case, and again, I'm not commenting on the correctness or not, but those are 2 decisions, and there's exactly one justice that thinks they're both right. Nobody would suggest that this is an area of the law where the court's precedents are crystal clear. And I think there may be some inevitability to that. There is a tension of sorts between the Establishment Clause on the one hand and the Free Exercise Clause on the other. And the court's cases in recent years have tried to consider when is an accommodation for religious belief, when does that go too far and become an establishment of religion? The court has a case on its docket coming up. I think the animating principle of the framers that's reflected in both of the religion clauses is that no one should be denied the rights of full citizenship because of their religious belief or their lack of religious belief. That is the underlying principle. That is, I think, what the framers were trying to accomplish. The jurisprudence, again, it's an area where the court has adhered through thick and thin to the Lemon test, probably because they can't come up with anything better. But the results sometimes, I think, are a little difficult to comprehend.
Now, of course, Justice Rehnquist had a different point of view, or at least he alluded to one when he appeared before this committee in 1986. Senator Simon asked him a question. He replied as follows: I have, in my opinions, read the Establishment Clause more narrowly than some of my colleagues, but I also think, Senator Simon, These are almost questions of degree, and that there is not a tremendous amount of difference there as to the broad principles of the Establishment Clause are uncontroverted. And those kinds of cases do not get up to us because they're pretty well settled. It is these kinds of frontier-type cases that come and reflect divisions among us. I certainly have read the Establishment Clause more narrowly than some of my colleagues. Do you feel that you are reading the Establishment Clause from a narrow point of view or from the traditional limit point of view?
Well, I don't think I've had an Establishment Clause case. The cases where I have argued obviously was representing the position of the administration, which was that the Lemon test was regarded by the administration as too manipulable, not determinative, and in some senses inconsistent. So those with the understanding of the framers. So that was the position that we were advocating there. I haven't expressed my personal views on the Establishment Clause in any context.
Well, let me read what you wrote in a memo on June 4th, 1985 to Fred Fielding. Again, this period of time when you were serving as a staff attorney related to Wallace versus Jaffrey. And here's what you wrote in reference to Establishment Clause and the Lemon test. Thus, as I see it, Rehnquist took a tenuous 5-person majority and tried to revolutionize Establishment Clause jurisprudence and end up losing the majority, which is not to say the effort was misguided. In the larger scheme of things, what is important is not whether this law is upheld or struck down, but what test is applied. I know you've said over and over again that you were just doing what you were paid to do, to tell the administration what they wanted to hear. Is that what happened here?
I don't think I've said that.
Well, that's correct. I strike that from the record. Let me just say you were a staff attorney reflecting the views of the administration you worked for. Is that a correct characterization?
It's a correct view. The views of the administration were quite clear with respect to the moment of silence, which was the issue in Wallace against Jaffrey. It was the President's view that it was constitutional, through the Attorney General, that it was constitutional to observe a moment of silence. Now, what the court held in Wallace, of course, was that you couldn't look at just the moment of silence. There was a history there about school-led prayer, and to substitute it and suddenly say, well, now it's a moment of silence. They didn't look at it in those terms, but looked at it in the long history. And the issue of whether a real moment of silence, without that kind of background and history, whether that would prevail or not, was one that the court didn't address in Wallace.
Let me just wrap this up by asking, and I think you've alluded to this, is it your belief that what we are trying to establish in the constitutional protection on the exercise of religion is not only to protect minorities, religious minorities, but also non-believers?
Yes, the court's decisions in that area are quite clear. And I think the framers' intent was as well, and that it was not their intent to just have a protection for denominational discrimination. It was their intent to leave this as an area of privacy, apart conscience, from which the government would not intrude.
Thank you. The next topic I'd like to talk about for a moment is executive power, which has been addressed earlier. It has not been a major focus in previous hearings, but obviously is now that we are at war. You've been asked a lot of questions about it because I think there's so much at stake. We'll probably be involved in this war effort, as Senator Leahy said early this morning, for some time. Throughout American histories, even some of our greatest presidents, including one from Illinois named Lincoln, tried to restrict liberty in an effort to provide more safety and security in our nation. This administration is no exception. They've claimed the right to seize an American citizen in the United States and hold him indefinitely without charging him with a crime. They've claimed that the courts have no right to intervene. I think that threatens all of our freedoms. Just last week, Judge Ludwig authored an opinion upholding the administration's position. And if you're confirmed, you may have the final word on this question. You and others have compared the role of a judge to an umpire, and I promised I wouldn't get into the baseball analogies. That's one thing I'll spare you from. But let me ask you this. When it comes to this use of executive power, you've referred time and again to Justice Jackson in the Youngstown case. Here's what he said. A judge, like an executive advisor, may be surprised at the poverty of really useful and unambiguous authority applicable to concrete problems of executive powers as they actually present themselves. So if you're confirmed, you'll play a significant role in determining what limits, if any, the Constitution places on a president during times of war. That's why the American people have the right to know what you think about executive power. There was an exchange earlier today between you and Senator Kyle about a statement I made yesterday about whether, as a justice, you will expand freedom in America. And Justice Kyle seemed to, Senator Kyle, I don't know something secret about that, but Senator Kyle seemed to suggest it was a zero-sum approach, that you couldn't enlarge the freedom of one person or group in America without taking away the freedom of another group. It's a curious point of view. It's the same point of view that Robert Bork had, that he tried to defend unsuccessfully before this committee many years ago. But my point to you is this. I'd like to ask you a question. What is it in your background or experience that can convince the members of this committee and the American people following us that you are willing to stand up to this president if he oversteps his authority in this time of war, even if it's an unpopular thing to do?
Well, Senator, I would just say that my demonstrated commitment to the rule of law, you can see that, I think, in my opinions over the past 2 years. You can see it in how I approach my job as a lawyer, arguing, and what types of arguments I make, and how I make those arguments, and how faithful they are to the precedents. And you can see it in my history of public service. The idea that the rule of law, that's the only client I have as a judge. The Constitution is the only interest I have as a judge. The notion that I would compromise my commitment to that principle that has been the lodestar of my professional life since I became a lawyer, because of views toward a particular administration, is one that I reject entirely. That would be inconsistent with the judicial oath. And Justice Jackson is a perfect example of that. He is someone who was a strong advocate for executive power when he was FDR's Attorney General, one of the strongest. And yet he could issue a decision like the Youngstown decision, not only concluding that President Truman lacked the authority, even in times of war, to seize the steel mills, but also setting forth the framework with the language of the sort that you just quoted, setting forth the framework about how to analyze these decisions in a way that is particularly sensitive to the role of Congress as well. That's the key feature of his framework, the examination of where Congress is on the spectrum in determining whether the executive has that authority.
I hate to keep referring back to these ancient memos, but it's said that if hammer's the only tool you have, every problem looks like a nail. And in this case, this is the only tool we have to try to find out what's going on in your mind and in your heart. And so, in a memo of 1983 to White House counsel Fred Fielding, you wrote, "The independent prerogative of the chief executive to determine that a given law is unconstitutional." You talked about the power of the executive to determine that a law is unconstitutional. We're going through this debate that Senator Leahy alluded to earlier relative to this torture memo and the idea that the administration would walk away from commitments that have been made under Geneva Conventions and under the Convention on Torture and would instead establish a new standard. So my question to you is this: would the anti-torture statute be unconstitutional simply because it conflicts with an order issued by the President as Commander-in-Chief?
No, Senator, not simply because of a conflict. And I have to say I don't know. That's one of the 80,000 memos I don't know about. So I'd have to understand what the point was, what the issue was, and the language you read in context before I could respond to that. But no, the President has an obligation. He takes an oath, as we all do, to uphold the Constitution and to make a determination. And his determination that certain things are either constitutional or unconstitutional can, of course, in an appropriate case, be tested in court. And the ultimate arbiter of that under our system is the federal judiciary.
Justice Jackson thought the bottom line on executive power was clear in Youngstown. He said no penance would ever expiate the sin against free government of holding that a president can escape control of executive powers by law through assuming his military role. I assume you agree with that statement by Justice Jackson.
Yes, I do. It simply reflects the basic principle that no man is above the law, not the President and not the Congress. And that's why the courts have the obligation and have had since Marbury versus Madison, to say what the law is, and if that means that Congress has acted unconstitutionally, they strike down the law. And if it means that the executive has acted unconstitutionally, they have the obligation to block the executive action.
We can imagine a hypothetical statute that would clearly intrude on a president's power as commander-in-chief, ordering the movement of troops and that sort of thing. On the other hand, the anti-torture statute is clearly within the area, I believe, where Congress can legislate. As you noted this morning, Article 1, Section 8 of the Constitution enumerates Congress's powers, speaking clearly that it says the Congress shall have the power to make rules for the government and regulation of the land and naval sources. So I think we've exhausted this topic, and I think we're in common feeling and agreement about it. I hope we are at least close. Let me ask you one last question in the few minutes remaining here. I've listened to some of the questions asked about gender and sex discrimination. They've come up repeatedly during the course of this. And as you look at the standards that are applied to the equal protection for a variety of different circumstances, there are different standards. I think you started to explain them at one point today. Maybe you got through the explanation, I'm not sure. But under strict scrutiny, the suspect classifications include race and national origin, religion, alienage, and the like. Then there is, of course, the other standard of what is characterized as middle-tier scrutiny, which includes quasi-suspect classifications of gender and illegitimacy. As you look back at the sweep of history that created these different standards, can you rationalize the difference between discrimination based on race and based on gender?
Well, I can tell you what the court has done. There are justices who aren't comfortable with the different tiers. They say there's one equal protection clause, but the different tiers are fairly well established as an approach to the different areas in discrimination. And the rationale for it is that there are areas in which you think it is almost never the case that distinctions that are drawn can be legitimate. Distinctions based on race or ethnicity, and so they're subject to the most heightened scrutiny. The rational relation test, which applies across the board to any type of law, they think there it's quite often the case that distinctions drawn on whatever basis Congress wants are likely to reflect the different sorts of policy judgments. Gender issues are in the middle tier because the court thinks that there are situations where distinctions can be justified, and there are other situations, but it's more than just the rational relation, but not as suspect as the most heightened level, because there may be other justifications. Cases throughout the court's history where they have upheld distinctions under that analysis, like the all-male draft, for example, that was upheld. Now, if you had applied strict scrutiny to that type of classification, perhaps the result would have been different, and the all-male draft would have been struck down. It reflects the court's determination that these are not sort of almost always inherently irrational and discrimination, rather than legitimate governmental distinctions, but that it's entitled to a heightened degree of scrutiny beyond the rational relation test. Justice Ginsburg, I think, in her opinion, in the VMI case, said that the intermediate scrutiny had to be applied with, I forget the exact phrase, exacting rigor or something along those lines, to indicate that it is well beyond the rational relation test, but it's not as inherently suspect as racial classifications.
Judge Roberts, thank you today for your patience with the committee and your responses to my questions. I think we all understand the gravity of this hearing, as you do, and we thank you very much for bringing your family and friends to be with you. Thank you.
Thank you.
Thank you, Senator Durbin, and thank you all for sitting through a very long proceeding today. We're in our 11th hour. Thank you, Judge Roberts. Thank you, Senator Leahy, here all day, and thank all my colleagues, most of whom have been here practically all day. Senators have other responsibilities, and when we set the time and stick to it, they know when to come in to find the time. There has been, I think, a spirit of goodwill generally, dignified generally, contentious at times, but I think productive. We will begin tomorrow morning at 9 o'clock, 9 a.m. instead of 9:30. begin at 9 a.m., and we will start with the questioning, 30 minutes to Senator Brownback. That concludes our day session.
Thank you.
John Roberts there talking with Kay Bailey Hutchison, Republican senator from Texas, a woman who is not on the committee. Members are returning tomorrow morning at 9 a.m. Eastern Time for the last two members on the committee to ask their round one questions, 30 minutes of questions, from Sam Brownback of Kansas and Tom Coburn of Oklahoma, both Republicans. 18 members on the committee. They, for the most part, 16 of them had 30 minutes today. We'll show you some of their comments from today on our companion network, C-SPAN 2, starting at 9 a.m. Eastern Time in its entirety. So today's confirmation hearing airing in about an hour, 7 minutes from now on C-SPAN 2.
Thank you.